Judge Stephanie Boyd thought the story didn't add up. An 18-year-old defendant claimed he was attacked right after stepping out of the shower, but one question changed everything. Where did the knife come from? Seconds later, the courtroom went silent as his own story collapsed.
Versus Paul Anthony Pettis. Could our parties announce for the record for the state? Defense.
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Pettis.
And are you Mr. Pettis?
Yes, Your Honor.
All right. You entered a plea of no contest on October 24th, 2023 to the offense of aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years in the prison. There's an affirmative finding of deadly weapon, and the state is silent on your application, and there's to be restitution. Have both parties had a chance to review the PSI report, state?
No, I haven't. I'm unaware that Mr. Sandoval was here.
Okay, no problem. I think we only requested the TAP evaluation and criminal history.
Yes, Judge.
And so do you all have criminal history to tender to me? All right. If y'all need time to get that, I can call the next case. All right, no problem.
Your Honor, if I may, on behalf of Mr. Pettis and for efficiency purposes, Your Honor, although PSI was not done, the TAP evaluation was done, and there was a notation on there about him being slightly motivated for treatment. And in my discussions with Paul over the last 6 months, shortly after him just turning 18, being arrested for this, he's well aware that his future is at a crossroads, that his entire life is at a crossroads, and that the activity with respect to substance abuse and his experimenting with that needs to change. That was not in and of itself the reason for what gave rise to this incident. Through no fault of his own, financial hardships led his family to living in for lack of a better term, a group home, which was a highly stressful situation. Mr. Pettis has reflected upon all this. As I said, he had just turned 18 upon his arrest. He's been in custody for 6 months, will not turn 19 for another 6 months.
So, counsel, let's just wait until the state is ready to give me the criminal history.
Okay, well, I was just informing the court with respect to the slightly motivated portion of the TAP evaluation. Oftentimes it comes across as the lack of motivation, where what's really intended is he doesn't want to be a problem to anyone.
All right.
Judge, yes.
Thank you. Any objections to the court reviewing the?
No, Your Honor. In fact, we appreciate it and
just judicial dialogue, Your Honor.
All right, thank you.
That's as an adult, and then PS and previous juveniles.
All right, counsel, you may continue.
And Your Honor, Mr. Pettis presents himself, and I say Mr., it really should be, as I said, it should be Master Pettis, presents himself seeking a chance from this court. As an adult under the criminal justice system, he has not had an opportunity to prove himself, not to the court or to the state or to myself, but to himself and what he can accomplish, especially given the sword of Damocles which hangs over his head should he fall short if this court, in its ultimate wisdom, were to allow him community supervision and the opportunity to turn his life around. I was taken by the court's attention paid to another young man earlier today. As odd as this will sound, Your Honor, it may sound odd to everyone in this courtroom, but what I wouldn't give as a 58-year-old male to be in Mr. Pettis's position right now, even though he's in an orange jumpsuit and in handcuffs, He's 18 years old and he has his whole future ahead of him. And what I wouldn't give to be 18 again. And if he only knew now what I know and what we the judge is far away from my advanced years, but what we now know. And it's given the totality of the circumstances of this young man's life. Society would not be harmed given the localized tension that gave rise to this event and him being given an opportunity. And if that opportunity also includes, we've discussed, Mr. Pettis and I, the necessity of some sort of substance abuse treatment, even inpatient, to begin the process to allow him to, again, not prove himself to this court or myself or Judge Garahan or anyone else, but to himself that this is not him. And it does not have to be him, nor does it need to define him. And Mr. Pettis presents himself to this court. Should the court have any inquiry, or should Judge Garahan have any inquiry of him?
All right. State, you're solid on the application, but according to the plea, it's a cap of 6 years.
And it's a cap of 6 years silent.
Oh, and you're solid on the cap as well?
Yeah, yes.
Okay. All right. Has anyone had any contact with the complainant?
He had some previous contact, Your Honor. They're aware of the.
All right. Anything you wish to say, Mr. Pettis?
I just want to say that I know what I did was wrong, and I'm very sorry.
So can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Paul Pettis.
All right, so what were you two arguing about?
We weren't arguing about nothing. I literally just got out the shower and he attacked me.
That's not what it says in the stipulations.
That's what it should say.
That's not what it says. Do you want a jury trial?
No, I don't.
All right, so according to the stipulations, it doesn't say you were outside and he attacked you. So you say you just got out of the shower and that's when he attacked you. I need you to say yes or no.
Yes, Your Honor.
All right. So you just get out of the shower, and I'm assuming you're nude because I don't know anybody who showers with their clothes on normally. So you were showering with no clothes on. Am I to assume that?
Yes, ma'am.
All right. So immediately upon getting out of the shower, did you have a chance to grab a towel or anything of that nature?
Yes, ma'am.
All right. So you grab a towel. Did you have a chance to wipe off with the towel, or did you just have it wrapped around your body?
I had a chance to dry myself.
So you dried yourself.
The courtroom of Judge Stephanie Boyd was about to witness a case that looked simple on the surface, but quickly unraveled under pressure. 18-year-old Paul Anthony Pettis stood before the court after pleading no contest to aggravated assault with a deadly weapon. The charge carried serious consequences, but his defense attorney hoped the judge would focus on one thing: his age. The attorney painted a picture of a young man at a crossroads. Financial hardship, a stressful living situation, substance abuse struggles, and 6 months already spent behind bars. According to the defense, Paul wasn't a hardened criminal. He was just a teenager who made a terrible mistake and deserved one chance to turn his life around. At first, it almost sounded convincing. The defense spoke about rehabilitation, treatment programs, and the possibility of probation. Even the state remained mostly silent, leaving the final decision entirely in Judge Boyd's hands. Then the judge decided to ask a few questions herself. That's when everything changed. Judge Boyd asked Paul what started the altercation. He claimed there wasn't even an argument. According to him, he had just stepped out of the shower when the other man suddenly attacked him. But Judge Boyd immediately noticed a major problem. That's not what the stipulations say. The courtroom tension instantly shifted. The judge carefully walked through his version of events step by step. He said he got out of the shower, dried himself off, put on clothes, walked out of the bathroom, and then came the question that destroyed his entire explanation. So, where did the knife come from? Paul hesitated. At first, he denied having a knife at all. Then he suggested it might have been scissors. But He couldn't explain where the weapon came from or how the victim ended up stabbed through the lung. Judge Boyd wasn't buying it. She had already reviewed the police reports and evidence. And according to those reports, the victim could have died. In that moment, any hope for leniency disappeared. The defense attorney tried one last time, arguing that Paul was immature, confused, and not trying to deceive the court. But the damage was already done. Judge Boyd made her ruling. She denied probation, found him guilty, and sentenced the 18-year-old to 4 years in Texas prison under a 6-year cap agreement. Still, even after the sentence, Judge Boyd offered advice instead of anger. She urged him not to become institutionalized in prison. She encouraged him to get his GED, pursue education, and seek treatment while incarcerated. But the judge's message was crystal clear. Youth may explain bad decisions, but it does not erase violent actions or life-threatening consequences. And with that, the gavel fell, ending one chapter of Paul Pettis' life and beginning another behind bars.
At a cap of 6 years. Give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Omar Morales Sastre, S-A-S-T-R-E. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And counsel, if you think it's appropriate, I'll request for him to be placed in the therapeutic community to address any mental health issues, if he has any, or drug issues.
Your Honor, any courtesies that can be extended by this court and its wisdom would be appreciated.
All right. And Mr. Pettis, you'll need to request the therapeutic community as well for them to even consider it. You understand?
Yes, Your Honor.
All right. We can go off the record. I realize that you're very young. I realize that going to prison or either going to the Bexar County Jail, any time that you do where you're not free is a lot of time, even 24 hours. But do not go to the prison and become institutionalized where you think that's the place to be. You can go there, you can get your GED, you can get a college degree, and they do not charge you for it. You understand?
Yes, Your Honor.
All right, good luck to you, okay?